This is a family appeal with 100 word per minute. G 5 4 3 2 1 start. 16 years after the marriage, Mehreen filed a suit claiming a house measuring one canal or its prevailing market value of 33 million rupees, which she said constituted part of her dower meher, and as mentioned in clause 16 of the Nikah-nama. Full stop. Both the father-in-law and mother-in-law filed separate appeals, but both were dismissed. Full stop. Thereafter, they filed two separate writ petitions before the High Court, but these two were dismissed. Full stop. It is against these three judgments that the two petitions under considerations have been filed. Semicolon. Musammat Khurshida Ishaq has filed civil petition for leave to appeal, and civil petition for is filed by the two sons and one daughter of Haji Muhammad Ishaq Jan, who had passed away. Full stop. However, Musammat Khurshida was not a party to the Nikah-nama and neither gave nor agreed to the property to Mehreen. Full stop. And Musammat Khurshida's husband was not given a power of attorney or any other authority to make a commitment on her behalf or in respect of the property, semicolon, where a father was held not liable under Muslim law for the dower of his son. Full stop. They next submitted that the family suit was filed in a family court, but the plaintiff Mehreen did not array her husband Mansoor as a party therein, nor demanded her dower from him, which defect in the suit was fatal to it. Full stop. The learned counsel state that in terms of section 2 of the Family Court Act, 1964, the husband was a necessary party because he was primarily liable to pay the dower, but he was not arrayed, nor did the learned judge of the family court order his joinder as a party. Full stop. By not arraying her husband Mansoor, it can be assumed, submit learned counsel, that Mehreen and Mansoor had collectively filed the suit to try to get the property without making Mansoor liable. Full stop. Concluding their submissions, the learned counsel state, that Musammat Khurshida and her husband, therefore, it was not necessary to array Mansoor as a defendant, and if the learned family judge felt that he was a necessary party, the learned judge could have impleaded him, but did not do so. Full stop. Mansoor's parents should abide by the commitment made with regard to the property at the time of the marriage. Full stop. In response to our query, we were informed by the learned counsel representing Mansoor and Mehreen that when the suit was filed, they were happily living together as husband and wife in Canada, continue to do so. Full stop. We have heard the learned counsel for the parties with their able assistance examined the documents on record, the judgment of the subordinate courts, the impugned judgment of the High Court, provision of the laws that have been referred to and the cited precedent. Full stop. Musammat Khurshida acquired land in the year 1964 on which subsequently a house was constructed. Full stop. It is also admitted that Musammat Khurshida was not a signatory to the Nikahnaama nor had executed any other document agreeing to transfer the property, either before or after a house was constructed on it, to her daughter-in-law. Full stop. Musammat Khurshida also did not grant a power of attorney or otherwise authorize her husband to make any commitment on her behalf with regard to the property, let alone to transfer it. Full stop. Musammat Khurshida neither held out that her husband was the ostensible owner of the property nor that she had authorized him to transfer it. Full stop. Mehreen also lead no evidence to show that she had attempted to ascertain that Haji Muhammad Ishaq Jan had the power to transfer the property. Full stop. Therefore, Mehreen could not avail the benefit of Section 41 of the Transfer of Property Act. Full stop. Therefore, unless a married woman elect to gift, sell or otherwise dispose of her property, neither her husband nor any male relative has any right over it. Full stop. Musammat Khurshida was not a signatory to the Nikahnaama nor had she at any stage agreed to transfer the property to Mehreen. Musammat Khurshida husbands could not have made a commitment on her behalf with regard to the property. Full stop. Mehreen also did not array her husband as a party to suit even though he was a necessary party thereto. Full stop. Mehreen undoubtedly had a valid claim against her husband with regard to the dower promised by him at the time of marriage, as mentioned in the Nikahnaama, and could claim the value of the property from him. However, she elected not to do so, but instead 37. The word of Almighty Allah in the Holy Quran and Sunnah, the teaching of Prophet Muhammad, peace be upon him, the dissolution of Muslim Marriage Act 1939, Section 2 of the Dissolution of Muslim Marriage Act, 1939-40, Article 2 to 7 of the Constitution of the Islamic Republic of Pakistan of the Constitution of the Islamic Republic of Pakistan, 42, Article 263 of the Constitution of the Islamic Republic of Pakistan states, inverted comma start, words importing the masculine gender shall be taken to include females, inverted comma close, be that as it may, Mehreen could still claim from her husband any part of her dower which remains unpaid. Full stop. Therefore, for the reason mentioned above, these petitions are converted into appeal and allowed by setting aside the judgment of the courts below and by dismissing the suit filed by the Mehreen against Haji Muhammad Ishaq Jam and Musammat Khurshid Ishaq. Full stop. There shall, however, be no order as to cost. Full stop. The end.